Creating a legally binding last will and testament in Maine doesn't have to be a daunting task. In fact, provided the right guidance, drafting a will can be rather simple. And best of all, it can be accomplished without seeking legal advice from a privacy lawyer. In this video, we'll discuss the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Maine, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, also simply known as a will, is a crucial document that allows individuals to determine how their assets are to be distributed among family, friends, and other beneficiaries upon death. It's highly recommended that all adults create a will, particularly those advanced in age. Now, let's consider what occurs if no will is left. A person who passes away without a will essentially loses control of who inherits their property. Instead, Maine law will dictate how the deceased's property is managed. The assets can often pass by default to the deceased's spouse, children, or other close relatives. Disputes between loved ones can inevitably arise when beneficiaries and their share of the estate are determined by state law and not the person to whom the property belongs. With that in mind, one can ensure their instructions are met by drafting a clear will document, and often without an expensive attorney required. A person of sound mind can draft a written will in Maine along with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's briefly review legal requirements in Maine. Last will and testaments in Maine must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though optional, it's recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created last will and testament templates specifically designed for Maine that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will, and don't forget to like and subscribe for more daily videos.